Okay, so here's it. You give us your ID or you're going to jail. So let's see your ID, bro.
My ID. You want me to remain in jail?
September 23rd, 2025, Palm Beach County, Florida. A grocery store call, a security guard, a gun on his hip, and a license that did not cover it.
How's it going? Who called?
I did that.
Not who?
I asked them to, that pick up and go back in his car. Because we have a lot of...
I got you. All right, boss man.
How you doing?
Who do you work for?
I'm working for the state and I'm working correction officer. And I work for Polk County.
You work for Polk County.
Yes.
And you're carrying around in Palm Beach County.
Not Polk County. I work for the Palm Beach Parking.
You work for who?
Palm Beach Parking.
Parking?
Yeah. Not parking. And I work for the state.
The Kennel Club, and you're carrying around a gun?
And I work in state too.
Okay, I understand that, but you're open carrying a gun. You're a
Yeah, because the law say you can carry
the 25th.
And the 25th.
On the
I
25th.
mean, probably they won't because I have the.
But even hold on. Even if so, if the business does not want you carrying a gun, you are not allowed to carry a gun in their business.
The law say it's only for the federal and then
Private business.
private business.
Private business. If they want to restrict you from carrying a gun, but it doesn't go in effect for another 2 days.
Okay, so even though that I'm in uniform to work. So the law.
You're a security officer. You're an armed security officer. You cannot open carry.
For now, I work for them, but I work for
It does not matter.
Okay.
You're not wearing any insignia other than a badge that nobody knows.
How you know that? I have my uniform on me. How you know that?
Okay.
Well, we don't know.
We don't know.
So
That's the thing.
I tell you.
Listen, we're not here to dispute or disagree with you.
Okay.
You have to understand, if you're going to open carry and you are identifying yourself as an officer, security guard, whatever, you have to carry clearly your firearm, a badge, and your ID card. Where's your identification or license for security? Your gun license card. Where's it at?
You want it?
Well, you have to show it. You have to be carrying with you.
You
You cannot conceal it. It's not about asking you. You have to display it on you.
Isn't on me? Isn't my badge?
On your person. Where is it? I don't see it. I don't know who you are.
Isn't my badge?
Okay, you have to carry it with you.
And that's you.
Let's go outside.
Come on.
This is clearly escalating. I don't want to cause some disturbance in this establishment. Okay.
Yeah.
And you tell me I'm a security right now, and I tell you I work for.
No, so what are you saying?
I don't know who else you work for. All you showed me was the Kennel Club. You're a security guard.
Either you are carrying for your organization, or you're carrying as a private citizen. What are you doing?
What information you want? I just want to know. I'm not allowed to come inside with the gun. That's what you said.
If they are refusing their service, yes, you are not allowed to go in there.
Okay. I understand that. Can I see your can I have your badge or whatever?
Deputy Herb 42589.
And Arguello 35632.
That's all I gotta give you.
I need the card. You have a
I
card?
don't have a card, dude. All I gotta give you is my name and ID number.
What's your ID number?
42589. I'm not gonna tell you again. So here that is. You're gonna
And
leave.
You know what? No, let me get your ID, please.
For what?
Because I am going to call your boss and tell him about our encounter.
I'm not gonna give you my ID.
Oh, so we're having an encounter. You're not going to give me your information?
No.
Is there an allegation he's walking out armed?
Oh, he's armed.
He's armed right there.
Criminal offense.
Yeah.
You have no open credentials. We don't know what you are. It's definitely a criminal offense. You absolutely need to use your ID right now.
Okay, so here's it. You give us your ID or you're going to jail. So let's see your ID, bro.
My ID. You want me to remain in jail?
Hey, guys. Stop. Hey, relax. Okay, relax. Hold on. Relax. Relax.
On his left side.
Okay. How about you cuff him? While we hold him. Hold on. I'll do mine. Okay. This is going to be our core color. So there's a secure one right there. There you go. There you go.
Where's your ID at?
what do you want my ID for? That's what I asked you. Before you ask my ID, I said, what do you want my ID for?
There's gonna be an escalating issue.
My ID is right here.
Wow, look at how easy that could have been. I could have just taken your ID, and that's it. But now I get to call your boss. Oliver Protection license. 14 Bravo. So take one by number.
This doesn't have a G license, right?
No.
It's all here to forget it.
This is it. This is all we were asking for. Your security guard.
Can I move my feet?
Keep it separated.
The security guard in there. This is all we were asking for, bro. You'd be going home tonight. Instead, you're going to jail. That's it, man. And I'll call your boss at the kennel club since I'm pretty nice with them, too.
Okay.
10-4. Switch it back. Stand back there for me, please.
It's okay, it's all right. I got it. Because I've been detained, I need all your names.
Again, I've given it to you twice. It'll be on your arrest paperwork as well. Okay, that's fine. Can you just stand back there for me, please? I'll give it to you.
I'm trespassing because clearly he identified that they asked him to leave and he wasn't leaving.
This is it. This is all we needed.
Hold on, this is a
It's a G license.
No, nope. This is a security license. I don't think he has a gun license.
We'll talk to you. Just give us some time, okay?
This isn't a gun license. This is a security license. Gun is red, unless
It's a G license.
Correct.
It says D.
It has to say G. Gun.
Yeah.
Are you hearing what I'm saying?
Yeah. It has to say G. Gun.
He
Yes.
doesn't have a gun license.
Yes.
And he's carrying as a security guard.
So he's open carrying.
Make sure it's your car is locked.
Just stay here. Carrying a gun, and he's got a D license, not even a G license. Security guard, open carrying a gun inside.
He's going to jail, not because of this, but because of what happened outside.
Oh, okay. Well, that's nothing to do with me. Then. All I wanted was for him to put the weapon. I even told him, listen, instead of
It's a D license,
Oh, nice, perfect.
not even a G license.
All right, wonderful. All right, then, thank you, appreciate it.
D.
D.
Ma'am, one of y'all. So who are you to Mr. Wesley?
His wife.
You're his wife?
Yeah.
Do you have the same last name?
No.
Okay. Do we need this? You think we need that?
Yeah. All that is evidence.
That is all being turned over to you, okay? That is all of his belongings. Okay. Oh yeah, and all these.
Where is he going now?
He's going back. He's going to jail.
To
Gun club. Yeah. Yeah. He's going to gun club for resist and open carry of a firearm. Okay. All you had to do was give us his ID. That's all we're asking.
I was telling him.
That's all we're asking for. Instead, now he gets to go to jail for it. Okay.
How many days?
That's up to the jail and judge.
Is he going to feel judge tomorrow?
Yeah, he should. Yeah.
You can go out. I can give you a touch time. You can go and check out tomorrow morning.
Olson! I was gonna say, I'm going to the district. 1251 district and 1015. Yeah.
Florida is not an open carry state. Under Florida Statutes Section 7, 90.053, carrying a firearm openly in public is prohibited with narrow exceptions. One of those exceptions applies to licensed armed security officers. But the license has to be specific. Not just any security license. It has to say Class G. Florida Statutes Section 493.6301 defines the Class G license as the Armed Security Officer credential, the only license that authorizes firearm carry during security work. Class D Florida Statutes Section 493.6101 is the unarmed security license. No firearm carry. At all. The distinction is not subtle. When officers pulled the subject's license card, it read D, not G. That single letter is what turned a welfare check into an arrest. Before that discovery, the encounter had a separate legal question whether the stop itself was lawful. Under Terry v. Ohio, 1968, officers need reasonable, articulable suspicion to detain someone for investigation. Here, the threshold was met. An open firearm, no visible employer credentials, a badge with no agency markings, and a dispatch call reporting impersonation. That combination clears Terry. Under Florida v. Bostick, 1991, the initial approach was a consensual encounter, no seizure yet. The subject was free to walk. He chose to engage. That matters. The impersonation angle, Florida Statutes, Section 843.08, did not appear to ripen into a chargeable offense. The subject identified as security, not police, but his framing was loose enough to justify the call. The deputy demanded a photo ID early in the encounter before the license issue had surfaced. That demand sits in legal gray area. Florida is a stop and identify state, but that right attaches only during a lawful detention. Under Hybel v. 6th Judicial District, 2004, the Supreme Court upheld stop and identify laws as constitutional when grounded in a valid Terry stop. The open carry situation gave the deputy enough. The subject argued he only had to give his name and badge number, not a physical ID card. That argument has some support. Hybel requires identification, not necessarily a document. But the resist without violence charge under Florida Statute Section 843.02 does not require physical resistance. Knowingly obstructing a lawful investigation verbally, through delay, through refusal, can qualify. The subject had the documents in his bag. He chose not to produce them for several minutes. The court will weigh whether that delay was a knowing obstruction or a protected assertion of rights. A second basis for officer authority developed separately: trespass. Under Florida Statute Section 8:10.08, remaining in a structure after being warned to leave is criminal trespass. The store manager had asked the subject to leave. He did not. That gave officers an independent ground to act separate from the firearm issue entirely. On use of force, the arrest involved handcuffing and physical escort. No weapons. No strikes. No injuries. Under Graham v. Connor, 1989. Force is evaluated from the perspective of a reasonable officer on scene, a subject with an unsecured firearm, unverified credentials, and an ongoing refusal to cooperate. That context supports a measured physical response. The force used was proportional and within policy. Now for grades. The deputy receives a B+. He correctly identified the Class G versus Class D distinction in the field that is not common knowledge. It is the kind of working legal fluency that prevents wrongful arrests. He held verbal engagement for over 3 minutes before escalating. He communicated charges clearly to the family. Use of force was minimal and controlled. Good work on the substance. The deduction comes from the early ID demand issued before the deputy had clearly anchored the detention to a specific articulable offense. The legal footing tightened up later, not at the start. The subject, Mr. Wesley, receives a C. The open carry violation is not a technicality. Florida Statutes Section 7, 90.053 exists precisely for this scenario. Someone armed without authorization in a public commercial space. He had the license card in his bag. He had the right employer. He may have genuinely believed he was covered. None of that changes the statutory requirement. Credit where it is due, he did not physically resist the arrest. When it came to it, he complied. That kept a bad situation from becoming a significantly worse one. The store management receives an A-. They made the right call. Reporting an armed individual with ambiguous credentials in a public store is appropriate. They cooperated fully on scene. The minor deduction, no evidence they had posted a firearms policy or verbally communicated one before calling police. That step could have resolved this before it started. A few lessons worth pulling from this. First, security licensing in Florida is not one license. It is a tiered system. Class D and Class G are not interchangeable. If you carry a gun on a D license, you are committing a crime, not doing your job. Second, the right to question a police demand is real, but knowing your rights and knowing how to exercise them at the right moment are two different skills. Refusal to cooperate during an active investigation, when you have the documents in your possession, is a choice with legal consequences. Third, private businesses have the authority to restrict firearms on their premises under Florida law, regardless of carry license. Refusal to comply after being asked to leave creates criminal exposure under trespass law. That is a separate charge entirely. At the time of this analysis, the court outcome in this case is unknown. Based on the footage, the open carry charge has strong evidentiary footing. The resist charge is closer. Courts will look hard at whether the delay constituted knowing obstruction. Let us know what interaction or legal topic you would like us to cover next in the comments below. Thank you for watching, and do not forget to check out our second channel, Bodycam Case Analysis Second Channel, for more police interaction and courtroom content.